Hello and welcome to The Big Picture. Today our focus is on the landmark judgment by the Supreme Court on triple talaq. A 5-judge constitution bench on Tuesday termed the practice as unconstitutional with a 3-2 majority. The bench has asked Parliament now to make a new law on triple talaq in 6 months. And if the law doesn't come in force in 6 months, then SC's injunction on triple talaq will continue. To help us understand the implications of this historic judgment, with us we have in studio Mr. Kamal Farooqui, former chairman of Delhi Minorities Commission and member of the Muslim Personal Law Board. We also have Deepak, Delhi High Court advocate, joining us as well. And we're also being joined from the capital by former Cabinet Minister Arif Mohammad and also Sanjay, Hegde, senior advocate of Supreme Court, with us. We'll come to all of you in a bit. Thank you so much, of course, for joining me here in The Big Picture. Mr. Farooqui, if I could start with you first. Yes, you've been having a busy day, of course. But give us, first of all, your reaction really, and what, in fact, the board also, how is it going to be reacting to this? We understand you have a meeting on the 10th of September. How, are they going to be embracing this verdict is what we want to know.
There are two things. One correction, that this meeting has nothing to do with this. In fact, that's a regular meeting. And this was...
but the council said
we already announced about 8 days ago.
Okay.
And we received the notices of the meeting. So that's a normal routine thing. But obviously when this meeting is here, we will be taking up all these issues also. We have got this judgment, plus we have got the other issues like Babri Masjid, we have to come forward, and other issues which are pending. As far as today's happening is concerned, yes, it's a landmark judgment, and we appreciate that the Honorable Supreme Court has gone into the details of the whole thing. But there are 3 sets of the judgments, in fact. One is the minority judgment of Chief Justice and the other gentleman, and the other is wherein they say that it is for 6 months, and then it will be. But this is the minority, so there is no need of any passing the judgment or something of that kind. The other part is that Mr. Korean has joined the hands with Chief Justice and the brother judge in saying that yes, it is covered under Article 25. And the personal laws have got the protection, wherein the other parties have been saying that it is not covered under Article 25. But the overriding for Article 14 is the covered. So that's a big relief to not only the Muslim but all the minorities in the countries, as well as the people who have been given the guarantee, constitutional guarantee, to practice their religious belief. So this is one part of it. The third part of the judgment is that it talks about the straight away banning the incidence of triple divorce in one go. So here also 2 silver linings are there. Earlier the government stand was that they wanted to ban all the divorce, all forms of divorces, and they had said it. And even now they are saying it, that we will go for the Parliament to decide about it. We have nothing to say about it, because this is a democracy and parliamentary system will have to work, and then we'll have to see whether the Parliament has got the overriding rights on the fundamental rights which are being enshrined in the Constitution. That is another part, and there's a long battle which we'll have to fight. But right now, what actually has been said, that the triple divorce, only triple divorce in one go instantly.
Yes, instant.
They say that it is banned. As far as Muslim Personal Law Board is concerned, we were never been appreciative about this form of triple divorce, and not now. 20 years ago, we had given a model nikah nama wherein we have tried to curtail this right of the men to greater extent by imposing the arbitration clause into it. Then recently, about 3-4 months ago, we have also brought in a kind of advisory saying that all those people who are doing this triple divorce in one go, they will be boycotted socially. Then we came forward with another advisory advising the Maulvis and the Qazis who perform the nikah that they must tell very clearly at the time of performing the nikah, because please understand that nikah is nothing but a sort of civil contract, and they have been advised that before going in for the nikah, you have to tell both the parties that and more particularly the girl, they have to put up a condition. They can put up a condition that triple divorce in one go will not be given.
But so that is exactly what the women activists, at least Muslim women activists, they've been saying that fine, that is what the board believes. But unfortunately, the enforcement of this was not strong enough, because the Maulvis were, of course, running their own rules, and the women, of course, were being subjected to this injustice, and that is the reason why, of course, they had to approach the Supreme Court. I'll come to you in a bit. But
let me just clarify it for a while, because this is being said about the women, etc. I just want to clarify one thing, that this is a kind of hype which has been created. Incidence of divorce among the Muslim is the least. We are not saying it. It is the census which says. And even the triple divorce is the least among the Muslims, and that too is being common amongst the uneducated poor classes. So that means that if you give the education, this will not be there.
Okay.
That is one part of it I wanted to
All right. I'll come to you and we'll talk more, of course, about this particular judgment as well. And we'll, of course, go to Mr. Arif. Arif Saab, I think, is joining us now. Arif Saab, you know, you spoke highly of the verdict in the Shabano case in 1985, we remember. And, of course, that was, of course, later set aside. But what do you, at least at the moment, make of this judgment?
This is a great judgment, historical judgment. I feel that today we are not in a position to make a realistic assessment of the impact that it would have on our social and national life. Awaaz gayi. And just now I heard about this. I have been hearing this for last many months. Incidents of lower incidence of divorce among the Muslims. It is true. It is true. But the fact remains that a Muslim girl grows with the consciousness that this unrestrained right is available to the man, and after her marriage, the husband can turn out of her marital home on any given day for any whimsical reason without letting her know what the reason is. The problem with in fact, I welcome the last affidavit which was given by the Personal Law Board. I welcome that, and I would like to say that this was. I won't say that they sensed the mood or something, but this was something great which they did when they said that this is a bidat, innovation. They said that this is an evil practice. They said they themselves want to put an end to it, but at the same time their spokespersons were insisting that it is permissible, it is permitted, it happens, there is no way you can do without it, etc., etc. And the other thing which has also been said is not correct about the Nikahnama. I have myself personally talked to the member of the Personal Law Board, lady member of the Personal Law Board, who had prepared the Nikahnama, and she told me that Nikahnama was never accepted by the Muslim Personal Law Board. In fact, she had to pay she was in the reconstitution of the board. She was no longer member of the board because she was insisting that Nikahnama should be accepted, wherein this condition was stipulated. So all these, I mean, we should not say things which are not true, which are not correct. The thing is that today this judgment has come. I am appreciating the Muslim Personal Law Board for the last affidavit which they had submitted. But to say that they were against it only verbally, but they were saying that it is enforced. As soon as the man makes three pronouncements, it is enforced. So this is a great judgment. We should welcome it, and it will have very positive impact on the Indian national life. Women will be equal participants. This judgment has come as
Mr. Farooqui would like to respond to this. Mr. Farooqui, you would like to respond to this. And talking about that affidavit, we'd like to tell our viewers as well, that was the affidavit where of course, it was said that brides now have an option to add in a clause in that Nikahnama. But the question also was raised, why did it come so late? Did you sense the mood of the country? Did you sense?
No, I think it's not correct. Arif Saab is good for not reporting the things properly. The Nikahnama is available on our website, not now, for years together, and there is thousands of the printed copies of the Nikahnama. But Nikahnama he's talking about, yes, there was another Nikahnama which was presented by that lady to the Muslim Personal Law Board, which was not accepted. But what I'm talking about, putting the arbitration clause and all those kind of things, it's a document, it's a well-established document. So Arif Saab, to be corrected on this fact of life. Number two is that as far as we are concerned, we have been always advocating that there, of course, even as on today we say it's a part of the Sharia. But it is a bidat, it is a thing which is not being liked by everybody. But it's an option available. We have been discouraging it, we are discouraging it, we'll continue to discourage it.
All right, since we are talking about this landmark judgment, let me go to Mr. Hegde there. Mr. Hegde, injunction, of course, to continue in effect, that means triple talaq, of course, is gone for good. But the point, of course, being pointed out is that the CJI was one among those judges who claimed that legislature cannot interfere in personal laws. What do we make of this? And, does this set a precedence of sorts of, cases of this nature to emerge further?
See, what you're reporting is not exactly correct. What you're reporting about the 6-month injunction is essentially that part of the minority judgment.
Okay.
Now, the minority judgment, it does not hold the field. The majority judgment holds the field. The majority judgment of Justice Nariman, which was joined in by Justice Lalit and assented to in a separate judgment by Justice Kurian, essentially holds the practice of triple talaq to be unconstitutional.
Okay.
The courts have now intervened to say that this particular practice, this particular form of divorce, which was otherwise protected under the Shariat Act of 1937, to that extent, the Shariat Act is unconstitutional. So therefore, we will not have any more triple talaqs in this country.
Okay.
There is no question now of
an injunction
Parliament
or a
being
time
required
period
to pass any legislation. Of course, there is no bar on Parliament legislating, but there is no requirement. That's the point.
Okay.
Today, the judgment has said that triple talaq is unconstitutional. Now, after having clarified the facts, let me put my personal opinion. My personal opinion is that this is a progressive judgment. Let the country progress. Let us go to a situation where the Constitution and its interpretation by the courts prevails. Let not this judgment be politicized for regressive agendas on either sides of the political debate. All that this judgment says is that this one form of divorce, which was also available to Muslim men, that the Constitution does not permit. So it is not as if other forms of divorce are not available. The proper form which has that a repetition of the talaq over a 3-month period, that is perfectly valid, and the law will accept that.
Okay.
You just can't divorce your wife by saying 3 talaqs in one breath instantly. The instant is gone, but the normal form of talaq continues and is constitutional.
All right. Deepak, how does a new law come about? What next steps do you see, on this front?
No, I'm not sure that a new law is necessary, and I agree with Mr. Hegde on this particular point for the simple reason that what was in challenge was itself a provision of an existing law, which is Section 2 of the Shariat Act of 1937, and what has been struck down as unconstitutional to that particular extent is that particular provision. Therefore, I'm not sure that there is a new law that is necessary. I think the biggest takeaways of this particular judgment would be the following. One, that it, and here I would just like to perhaps add to what Mr. Farooqui just mentioned. Rights under Article 25(1) insofar as religious freedoms are concerned are not available only to minorities. These are available to everyone. That's point number one. Okay. Point number two, the state's right to intervene with anybody's rights, or at least religious rights, is equal, at least on paper, across the board, when it comes to, let's say, legislative mechanisms being used to usher in social welfare or social reform. That's point number two. Point number three, the reason why triple talaq has been rendered unconstitutional, at least by, let's say, the majority judgment, that is Justice Kurian, Justice Lalit, and Justice Nariman, clearly say that triple talaq is not seen as an essential part of the practice of Islam, and therefore it is not an essential part of the faith. In fact, the opening paragraphs clearly say that this is particular only to Sunnis and not to Shias at all in the first place. And then they go on to say that since it's not seen as an essential part of the faith, its protection is not necessary, and it cannot seek the benedictions of Article 25(1) insofar as religious freedoms are concerned, and therefore there is no need for a separate law for it to be banned or forbidden, because if it's not an essential part of the faith, it does not have the protection of Article 25(1), and therefore a law is not necessary.
All right.
And to that extent, I think they strike a beautiful balance between being progressive and also abiding by constitutionalism, because the biggest fear in situations such as these, or in judgments such as these, is there is a savior complex once in a while that creeps in, wherein we try to do justice perhaps at the expense of the Constitution and constitutional interpretation. In this case, I don't think that has happened. the court has abided by the constitution, stuck to the framework of the constitution, and has come out with a categorical finding that this practice has no sanction, first of all, in the faith, and therefore it is not an essential part of the faith, and therefore it is bound to be struck down for being anachronistic and for being patriarchal in nature. So I think these are the things, and to answer your question again, there is no need for another legislation, simply because it was treated as part of a legislation, it was treated to be a part of Section 2 of the Shariat Act, and now it has been rendered unconstitutional.
All right, but then why the need to mention that Parliament has to, of course, come out with a new, there was a mention, of course,
No, but that is a minority.
That's
that was the minority's view. And
the minority view was basically this, that the rights under Article 25(1) are sacrosanct, and therefore they can be interfered with only through a legislation under 25(2).
Is that going to be the board's view now from now on? And for that matter, will there be a retrоспective effect to previous victims of instant triple talaq? Do we see anything of that sort?
In fact, my learned lawyers have to think, and we'll also take up a view. But as far as I personally feel that perhaps this would be from the not from the retrospectively.
Prospective,
exactly. It has to be prospectively. But again, we have to go through the whole thing. And as far as board is concerned, let the people say whatever they feel like saying it. But we are on record that we have been not now. We have been talking in all our social reforms meetings, in khutbahs also, in model nikah-nama also, in advisories also, to desist the people from pronouncing triple divorce, because it's a curse. And it is a kind of allowable action under Sharia, but not liked by anybody, not even Prophet Muhammad Sallallahu Alaihi Wasallam. So this was a step, and it is also correct that this practice is being accepted by almost 90% of the Muslim population in the country, which follows the Hanafi Sharia law. As far as the other school of thoughts like the Shias and the Ahl Hadith and Shafis, very little amount of there. But still, Honorable Supreme Court has gone into it, and will go into the judgment also, because it has, as my brother has very rightly said, that they have taken out from the Shariat Application Act 1937. But as far as the interpretation is concerned, still there is a wide gap in understanding whether it's a part of the Sharia or not. As far as we are concerned, though it's a part of the Sharia law, but it should not be done the way it was being done by the people. And that is what actually we are aiming at. To this, we feel that Honorable Supreme Court has done a good balancing job, but still, by saying it is not a part of Sharia, I think we have to look into it again.
If I may just add one point.
Yes.
Building on what Dr. Farooqui has just mentioned, if going by his logic, if let's say this were to be treated as Sharia, and we still accept the permission, or we still accept the interference or the intervention by the court to strike down something which is seen as part of Sharia, that would perhaps mean that according to Dr. Farooqui, something which is integral to the practice of a faith can also be interfered with by the court or the legislature, which I think is an extremely progressive position to take.
And is that in fact, Mr. Arif, if you could come in here, is that something that we'll be seeing in future?
That is not what the court has held.
Please elaborate. Please elaborate.
Sorry. Elaborate what?
Mr. Hegde, you were trying to make a point?
No, Arif.
Oh, sorry, Mr. Arif, you were trying to make a point?
Yes. No, the point is...
No, I was asking, I thought you are asking a question. I could not hear your question.
Yeah, Mr. Arif was trying to make a point there. Mr. Arif, could you elaborate on what you were saying?
Oh, I thought you asked some question which I had not heard. But
all right.
The position which Mr. Farooqui is taking, in fact, I would like to welcome this position. I would like to welcome this position, because we must try to understand that the Muslim girl grows with this consciousness that her husband has this unrestrained right to divorce her after marriage. He can divorce her on any day. This sense of insecurity which takes grip of her, which distorts her thinking. The basic thing is that why this right, which is not available to any Muslim man anywhere in the world, should remain available to a Muslim in India. The Shariat, Islamic Shariat, is different for India and is different for Saudi Arabia. It is India different, and Pakistan it is different. Pakistan is also a Hanafi country, but the law does not recognize triple divorce. And now instead of going into all these past details, this is the time when we should welcome the judgment.
This seems to
and
be a
should
recurring debate, isn't it, Mr. Farooqui?
Try
It
to
seems
see that it is implemented in letter and spirit.
there seems to be a recurring debate. Each time we discuss the marriage laws, of course, within Islam, this seems to be a recurring debate on how several countries, of course, have abolished certain practices that is not necessary in Sharia law. However, it continues in certain areas and continues, of course, in India as well. Can you clarify on this?
Even on this, I will clarify.
Only India.
I think that's the problem with Arif bhai. He doesn't listen. It is not only in India. This is incorrect. And that is what Honorable Judge has also appreciated. And I will read out the whole thing. He said, having said so, and that is what actually Justice Kehar and other brother has said, having said, low down we exercise power to the Article 145, it's so and so, so and so, and to legislate in respect of the Tribunal in accordance with the evolution of practice in other jurisdictions, including Islamic countries also. They say this is not correct. This is not correct, and what Arif Sahib is saying, in fact, this is also not correct. He refers about 22 countries. 22 countries, there is absolutely the condition was differently, and we don't want to go into all these debates. Recently, there was a meeting of all the school of thoughts in Saudi Arabia, stating about this kind of triple divorce, whether it is valid under the Sharia laws or not. It has been unanimously said that though it should be avoided, though it is not likened, but it is a door. It's available option. Okay. Which should be used with restraint, and sometimes it is to the benefit of the women only, because if there is a situation when the marriages are not in a position to go through properly, and they do not want to live in for a night, so then it comes handy that they can separate with respect and they can have their life instead of going to the courts and all those kind of things. But this is not the point of discussion over here. Even saying this, that it is not available anywhere in the country, this is wrong. Okay. This is a wrong perception.
Okay. Mr. Hegde, I'll give you the last word here because we're running out of time. This judgment, of course, being hailed as something which is crucial for women empowerment, and not just about Muslim women as well, but women of other minorities as well. If they have a problem with personal law boards, then they can, of course, go on to the, they can go on to the judiciary, they can go on to the Supreme Courts, they can go on to the courts, and that, of course, is crucial, and their voice will be heard. Do you agree with that?
Well, every time people, whoever have a problem, can approach the courts. The question is whether the courts can deal with it. Today is a problem where the court has dealt with it. The court has basically traced the power of triple talaq to one particular section of one particular pre-independence act and said that that power no longer exists because it is unconstitutional. It has held it to be unconstitutional because it is plainly arbitrary. Now, the court has not gone much beyond that. The court has not defined what arbitrariness is. This judgment on triple talaq is much more important, not for triple talaq, but for the general right of a citizen to approach the court and get laws struck down, irrational laws struck down as purely arbitrary. Now, this particular judgment, to my mind, would be greatly useful when a second challenge to Section 377 of the IPC, the homosexuality judgment, when that comes up for review, this judgment will be greatly useful, because every law which is arbitrary is now liable to be struck down. Right. That is the true import of this judgment.
Absolutely. Deepak, yes?
Assume for a moment that the Supreme Court had not found itself in a position where it could have traced the practice of triple talaq to Section 2 of the Shariat Act. That would have been the true question as to whether the judiciary itself can take upon itself the responsibility of interfering with personal laws and freedoms. Okay. In the absence of it being law under Article 13, without there being a legislative mechanism or a legislative framework which is under challenge. Okay. So assume for a moment that triple talaq had not been found to be under Section 2 of that particular act. Could the Supreme Court have interfered with it? And that's a question that needs to be answered. And that's one of the questions that Justice Fali Nariman has indicated, which needs revisitation at a later point of time, citing a previous decision. So that's a question which is still open.
It's still open.
So this is not a judgment which basically says that everybody can approach the court to challenge certain personal laws, unless and until it is traceable to some provision of some act.
Okay.
unless and until it is a law as far as Article 13 is concerned.
All right,
that
that's
needs
crucial.
to be understood.
That's crucial indeed. We'll leave it there for a moment. Gentlemen, thank you so much for joining us. I believe Mr. Arif, of course, is left as well. But thank you for joining us on The Big Picture. That's all we have for the moment. This debate, of course, will continue. Thanks so much, though.